Good afternoon, and welcome to the University of Richmond School of Law. Today, the Intellectual Property Institute presents the second annual Evil Twin Debate. Our evil twins are Professor Mark McKenna from St. Louis University School of Law. Professor McKenna is visiting and has accepted an offer at Notre Dame Law School for next year. And Professor Stacey Dogan from Northeastern University School of Law, and Professor Dogan is visiting at Boston University School of Law this year. They will be debating the topic, is a trademark use requirement useless? To begin, I'll provide a short introduction to the issue, and then Professor Dogan will have 15 minutes to argue her side of the issue. Professor McKenna will respond with 18 minutes of his own, and then we'll hear a 3-minute rebuttal from Professor Dogan. Questions and answers from the audience will take us through the end of the hour, and then we will retire to the atrium for a light lunch. This is the second Evil Twin Debate hosted by the University of Richmond School of Law, covering important topics in intellectual property and related fields. The series and its name come from the notion that experts often disagree on important policy issues, yet remain very friendly on a personal level. We therefore seek to bring together pairs of scholars who can air their disagreements in a friendly exchange, serious in substance, but lighthearted in tone. It's with that theme of lightheartedness in mind that I present today's two debaters. You see, rather than asking each of them to provide his and her own biographical information for the introduction, we asked each to write the other's biography. This is what they wrote. Mark the Monster McKenna is a professional mud wrestler hailing from Chicago. The monster, who burst onto the scene some 6 years ago, takes pride in slinging mud at what he describes as the conventional wisdom of intellectual property. His take-no-prisoners approach has but one objective: to rewrite the canons of intellectual property theory. His so-called monster creed includes such edicts as, "It's the producer, stupid," and "Everyone has a right to her autonomously self-defined self." He has been described as everything from a rigorous, creative thinker at the top of his field to heroic, though ultimately unpersuasive. He doesn't mince words. He once described his opponent, Professor Dogan, as pathetic. Be prepared for the power of the monster. Professor Stacey Dogan, known variously to her colleagues in the IP community as a leading scholar and pathetic, conspires with Mark Limley to rid the world of evil search costs. Beloved by Google, Dogan and Limley will not rest until branded goods turn up unannounced in your living room and every man, woman, and child in Greater Boston owns a counterfeit socks cap. Dogan is also a talented vocalist who's been known to liven up conferences with her basement musical performances. Should this debate have to be resolved by karaoke, Dogan holds a decided advantage. Now for a brief introduction to the issue, which will not be nearly as funny as what these debates. The question of trademark use is an ongoing debate among scholars, judges, and practitioners alike. Some argue that trademark use is a threshold requirement for trademark infringement claims. Professor Dogan is of this school of thought. Others argue that trademark law doesn't impose limitations on the types of uses that subject one to infringement liability. Still others argue that the trademark use question is an integral part and not separate from the likelihood of confusion analysis. And Professor McKenna represents this view. To give an example, let's say an internet search engine, let's say Google, has a program by which companies can purchase words that will trigger their ads when users enter them in the search query. Google sells the trademark of, a car insurance company, let's say Geico, to competing car insurance companies. if GEICO decides to sue Google for trademark infringement, what's the outcome? Has Google used the GEICO mark? Well, in fact, the court said in this case that GEICO failed to prove that Google's use of the GEICO mark in its AdWord programs created consumer confusion, which begs the question, is a trademark use requirement useless? Let's get ready to rumble.
Mark has given me permission, or in fact, I think instruction, to contextualize the pathetic comment. He was referring not to me in my scholarly capacity, though I'm sure that he feels that way about my scholarly capacity as well, but he was referring to me as a Red Sox fan, talking about how historically the Red Sox fans have had so little confidence in their teams that they were basically pathetic. And he said it with just that tone of voice, virtually, over the internet, by email. So I was really interested in that introduction to this issue and the focus on the outcome in these cases, because I actually think of trademark use in some cases as not necessarily outcome determinative. I think of the question as distinguishing between parties who can be engaged in acts of direct infringement on the one hand, and parties who cannot be held liable unless they're being held liable under standards of secondary liability on the other. In other words, I wouldn't say that Google should be entirely exempt from liability under trademark law because it's not engaged in trademark use, but that it should be evaluated as a kind of contributory infringer for facilitating infringement by others. Let me give a little bit of background on my pathetic theoretical framework before I launch into the issue at hand, because I think it's actually important in understanding where Mark Lemley and I come from on these issues. We view the purpose of trademark law as improving the quality of information in markets. The law protects trademarks against diversions of trade, as Mark McKenna points out, by others, confusing diversions of trade by others in order to protect consumer expectations about the information that is embedded in marks. So consumers have all sorts of expectations that are built into their understanding of marks, where a product comes from, the quality that comes along with the mark. There's meaning, right, imbued in trademarks. And if other people are allowed to use marks in ways that suggest that their products actually come from the trademark holder, right, the consumer's expectations, the consumers are misled and their expectations are dashed. So the goal of trademark law is to allow consumers to rely on trademarks as reliable sources of information, right, about the source, quality, and other information about products and services. That goal comes with important limitations, right, that are built into trademark law. So you are allowed to use trademarks, even other people's trademarks, in ways that inform rather than deceiving. You're allowed, for example, to engage in comparative advertising, to use trademarks in informational ways, any of these ways that help to inform consumers and not deceive consumers, improve information in marketplaces, make consumers aware of products that they might not otherwise have known about, and thereby promote the goals of trademark law. So trademark law protects marks as an intermediate effort in order to promote an ultimate goal of promoting competition, right, in markets. So it's ultimately supposed to be a pro-competitive law. The core of trademark analysis is and has always been the question of likelihood of confusion between the two parties' products and services, right? So if someone uses a trademark on their own products or services, the question has always been, well, are consumers going to be confused into thinking that that party's products and services were somehow made by or sponsored by the trademark holder? And the opponents in the trademark use debate point to that centrality, point to the centrality of likelihood of confusion as evidence that there isn't and there never has been any threshold requirement that defendants actually use the mark as a mark, right, in selling products or services. Recently, however, trademark holders have brought a series of lawsuits, as Melanie pointed out, against parties based on their use of trademarks in non-traditional ways, right, ways that people didn't historically claim constituted infringement. The use by Google of trademarks as an indexing tool, essentially, to identify consumers who might be interested in particular types of products or services, is not a traditional use of the mark as a brand on a competing product or service. And so the questions that are being raised by these cases are just different than the questions that were raised in the classic trademark infringement suit, in which the defendant was selling or marketing its own products or services under the mark. So the trademark use debate, we argue, has never been confronted directly by the courts because it's never been presented to the courts. And your view of the equities of the situation, or whether the courts are making new law or simply affirming rules that have always been implicit in the law, really turns or can turn on how you look at the question. Are you looking at it as my good friend Graham Dinwiddie and Mark Janus argue? Do you look at trademark use as courts creating a new legal doctrine that limits pre-existing trademark holders' rights? Or do you look at it, as Mark Lemley and I do, as the courts trying to understand or keep trademark law faithful to its historical goals and limit new causes of action, new encroachment by trademark holders into areas that have historically been outside of their control? All right. So the question that this debate addresses is really whether a doctrine of trademark use can serve as a useful limiting principle in some category of cases without resort to a complex balancing of factors that's inherent in the likelihood of confusion analysis. Essentially, can we or should we have a threshold inquiry into whether the defendant is engaged in use of the mark as a mark before allowing plaintiffs to proceed into the question of whether consumers might somehow be confused, right, by the use in some way. And Mark Lemley and I think trademark use can serve this useful limiting function. Let me tell you, before I go into what we do claim, what we do not claim. We are not claiming that trademark use is a so-called wonder theory, as we have been accused of claiming, that is not by you, by the way. Yeah, he hasn't been responsible for all of the mudslinging against Mark and me. We're not claiming that it is capable of reining in every excess of modern trademark law. Indeed, we've written a number of other articles that point to other doctrines that can be useful in reining in other excesses of trademark law. We are also not claiming, I think, contrary to Mark McKenna's characterization, we're not claiming that it can serve as a useful threshold inquiry in every case. Sometimes the question of whether a defendant is using a mark in a way that indicates source or sponsorship is inextricably intertwined with the question of how consumers are going to perceive the use of the mark. So, for example, if I am using a mark on a package of my products and services, and I happen to be a competitor of the trademark holder, the question of whether my use is one that indicates source is highly contextual, right? You can't really answer that question without looking at the context of the use of the mark. Am I using it in a descriptive way? Am I using it in a way that compares my product to the trademark holder's product? And in those circumstances, I would agree that trademark use cannot serve as a useful threshold inquiry. The third thing that we are not claiming, as I mentioned a moment ago, is that defendants who have not engaged in use of the mark as a trademark for their own goods or services should be completely insulated from liability. I think there are many circumstances in which intermediaries or parties that facilitate other parties' infringement can and should be held liable. They have historically been held liable and they should continue to be held liable, but their liability should turn on the intimacy of their relationship to the other party and its infringement, the level of knowledge that they have of the infringement and the extent to which they are integrally involved in it. All right, so what do we claim? We claim that the doctrine of trademark use can serve as a limited surgical tool for cabining the expansion of trademark claims against certain categories of behavior that have never been considered to be trademark infringement in the past. In particular, parties who are not themselves marketing their own products under the mark. So we define trademark use in a way that focuses on whether the defendant is in fact marketing its goods and services under the mark in a way that could even plausibly be interpreted to suggest or indicate the source of its products or services. So selling my own handmade running shoes with a Nike swoosh on it would clearly be a trademark use, right? This is holding myself out to the public or holding my product out to the public under someone else's brand, right? This is a branding use of the mark that is used in connection with the sale or offering of my goods or services. Writing an article about Nike is not. And neither is providing a list of stores, right, that sell Nike sneakers. If I'm an online shopping intermediary that's trying to identify locations on the web where I can find Nike sneakers, along with price comparisons between these stores. The latter two are both examples of uses of the mark, certainly, and uses of the mark in commerce, but they're not uses that suggest, even arguably, right, that Nike is a source or sponsor of my products or services. Now, Mark McKenna, mudslinger that he is, contends that the doctrine is useless. Because it turns by definition on consumers' expectations, which are highly suggestible and subject to an ever-widening understanding about the scope of sponsorship relationships. So he would say, well, actually, that list of stores that sell Nike online, consumers actually might think that Nike has sponsored that list because consumers understand that there are paid placements, that movies are filled with paid product placements. And every time you see a mark, you might actually wonder whether that mark holder paid to sponsor, right, this list or this product or service. Now, I actually think, that's a fair point, but I think it's important that the law think of itself not solely in terms of existing consumer expectations, and that legal doctrines define themselves not just in terms, as Jim Gibson has pointed out, of this sort of slippery slope of what consumers might conceivably think might be some possible relationship in the future. But I think it's important that courts craft legal doctrines that check these impulses or check these dangerous slippery slope trends before they actually have occurred. So we view trademark use as useful in limiting trademark holders' claims into these new categories of behavior. That yes, if the law continued the way that it did, maybe consumers might someday come to expect that Nike has actually sponsored every single use of its mark in commerce. But I don't think we've gotten there yet, and I think most judges would agree that we haven't quite gotten there yet, and I think most judges would agree that for important normative reasons, we want to prevent the law from going there. So we would suggest that the trademark use doctrine serves as a useful kind of line in the sand to prevent the law from going so far. In particular, the trademark use doctrine is useful in distinguishing between parties who use a mark in some way that brands or markets their own products on the one hand, and those whose use of the mark at best is helping to call attention to some third party's product on the other. Now, how does this fit into other areas of so-called non-trademark use? There are a number of other areas of the law that insulate parties whose use of a mark is not in connection with a branding kind of use, but that the law specifically insulates from liability and surgically insulates from liability in a very specific way. And let me just give a couple of examples. Descriptive fair use. If someone adopts a mark that is descriptive of their products or services, that mark is not entitled to trademark protection immediately, but it can acquire trademark protection over time if it acquires secondary meaning, such that consumers, when they see the mark, think of it as a brand rather than just a descriptive term. Now, other parties can use these marks in their descriptive sense if they're doing so in good faith in a way that accurately describes their own products and services and not in a source indicating way. Now, Graham Dinwiddie and Mark Janus have argued that because trademark law specifically exempts this one category, right, of non-trademark use, that it must presume that other categories of non-trademark use are automatically actionable unless specifically exempted from liability. Right? Now, what Mark Lemley and I, there's too many Marks in this conversation, but what ML and I argue is that this is one example of a doctrine in which the courts have recognized that for important policy reasons, this is a use that is not a trademark use and in which the error costs from a pro-plaintiff verdict. If a jury mistakenly said, yeah, this is trademark use and we do think consumers might be confused, the error costs would be high. Because defendants in these cases, right, would not have the linguistic tools accurately to describe their own products and services. So we think of it as kind of a safe harbor. Yes, it is an example where the courts have said, well, when you're not using the mark as a mark and you're using it in a descriptive way, and you're acting in good faith and blah, 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 then you'll be exempt from liability. And we say, yeah, courts have recognized that in these circumstances, this particular category of non-trademark use should be protected by a kind of safe harbor. And there are other examples in the statute and in the common law of these so-called safe harbors, examples of uses that are not trademark uses in the sense that the mark is being used in a non-source indicating way, right, and that promotes important trademark-related values, in which the courts have said, we're going to exempt you from liability even if there's some conceivable risk that some consumer might be confused, because we think important informational goals are promoted by this use. So these categories of so-called safe harbor, what I've described as safe harbors, share two characteristics. Number one, the defendant has used the trademark in a non-source identifying way. And number two, the error costs from a pro-plaintiff verdict are high. And we argue that this whole category of intermediaries satisfies this definition. Intermediaries, to the extent that they are not branding their own products or services under a mark, but may be facilitating other people in using a mark to call attention to their products and services, right, are not engaged in use of the mark as a brand for their own products and services. And the error costs from a pro-plaintiff verdict, from a mistaken finding that these defendants are using the mark as a mark and confusing people, are high. That was a really long sentence, sorry. And let me just give you a couple of examples and then I'll wrap up. Just so we don't lose sight of the fact that the Red Sox are actually really cool. And, sorry, my talks all somehow come around to the Red Sox. The last time I saw Mark, I was in St. Louis the day after the Red Sox beat them in the World Series a few years ago. So, but let's suppose someone is searching for the Red Sox online, types in Red Sox, right? Should a bar down the street from Fenway Park be able to place an advertisement in response to that search query? Or what if someone types in bar down the street from the Red Sox, right? They are clearly asking Google to use the Red Sox's trademark in a way that calls attention to products and services that are complementary to the ones that the Red Sox are offering, and that arguably are competing with the ones that the Red Sox are offering, because the Red Sox sell very expensive beer at and in, right next to Fenway Park. Should those kinds of uses be prevented? Or let me give you another example that Eric Goldman likes to give. Let's suppose I'm searching for a Canon camera. Should Nikon be able to place advertisements, or should Google, be allowed to accept paid placements for advertisements that appear alongside the search results for my Canon camera? Well, should they be able to accept advertisements from Tamron that makes lenses that are cheaper, that work with the Canon cameras? Well, what about advertisements for a photography magazine, right, for people who are interested in photography? There are all sorts of people who are selling products and services that are both competitive with and complementary to the brand that the customer is looking for. And if, as a matter of law, these intermediaries are found to be engaged in trademark use, there's a risk that some jury somewhere or some judge, as the Ninth Circuit did in the Playboy Netscape case, might be persuaded that consumers are so gullible that they're going to think that somehow this trademark holder sponsored every ad that appears next to the search result. And in those circumstances, we argue the public would be so much worse off because it wouldn't become aware of the products and services that are competing with and complementary with the trademark holder's product. So as a normative matter, we think it's important that courts come up with some kind of defining doctrine that limits the liability of intermediaries, largely in the same way that the liability of intermediaries has been limited in the copyright law context, right? Allow for the development of these non-infringing, important information facilitating uses. Just two more points, and then I will turn things over. I'm probably out of time, but yeah, sorry. Less time for you. All right. In the paper that we've written on this, we make both historical and normative points. And I've focused mainly on the normative or policy-oriented arguments here, but I just want to make a quick point on our defense of the argument that some kind of trademark use requirement has actually always been implicit in trademark law. It's not that courts have identified trademark use as a requirement for infringement, right? But there is a long series of cases in trademark law that have distinguished between direct infringers and contributory infringers. Direct infringers have always been presumed to be parties that are themselves branding their own products under a mark. And contributory infringers have been those whose liability or whose connection to the infringement is to facilitate, right, that other party's offering the product to the public under the mark. And the fact that the courts have historically distinguished between these two causes of action, these two doctrines, suggests to us that there is implicitly a requirement that in order to engage in direct infringement, you have to actually offer your product to the public under the mark in a way that is potentially deceptive. The final point is this distinction between norms shaping and norms reflecting goals of trademark law. Trademark law has always, and Graham Dinwoodie and Mark Janus make this point, has always been norms reflecting in the sense that the standards for trademark infringement have asked whether consumers, as they currently exist, are likely to be confused by a defendant's use of a mark. And we think that that's not an inappropriate approach, but we think that courts, especially in this era in which we're facing new technologies, new different kinds of uses of marks, need to be mindful of the norms shaping role of the law as well. And that if the courts use small possibilities of infringement of confusion as a basis for finding infringement and preventing behavior that could be pro-competitive in the end, that will have the effect of shaping consumer expectations and just making them more confused in the future, right? When people use trademarks in ways that may be unauthorized by the trademark holder, but may be very important for competition-related purposes. So we think that courts shouldn't abandon the norms-reflecting approach, but that they should be mindful of the effect of the law. And this is Jim Gibson's big point in his recent work. They should be aware and conscious of the fact that an overly generous approach to trademark holders' claims here would have the effect of simply expanding rights, because consumer expectations will be that the trademark holder has the right to prevent virtually every unauthorized use of its mark. And now, what did I call it? The monster.
Well, I was a little worried when I was told I had 18 minutes because I thought I only had 15, so I don't know if I have enough material to cover the extra 3 minutes, but I think Stacy used it anyway. So, so I think we're fine. So I just want to say I think we can all agree that that was, in fact, pathetic, right? So we can start with that. No, I do want to say thanks to Jim and to Chris and Kristen and Melanie for inviting me. I'm happy to be here to talk about this with Stacy, who is a leading thinker in trademark law and whose ideas, though often pathetic, deserve careful attention. I should say though that since I think I heard her say there that she doesn't necessarily regard trademark use as a way to get Google off the hook, then I take back what I said about being beloved by Google. Right. So I think Google's going to have to be a little more ambivalent. So at risk of maybe jeopardizing the tone of the debate, I'm actually going to start by talking about areas where I think Stacy and I agree, both because there are several and because I think it'll help bring our areas of disagreement into a little sharper focus. So first, I agree with Stacy and Mark that there's a really serious problem in trademark law. I think that trademark law has gotten too broad and it's too indeterminate at the boundaries for parties who want to make a use to know ex ante with any confidence that their use is going to be legitimate. Right, so this is again, I'll sort of acknowledge Jim. Jim's described this in much more detail, but the problem is that when you have a system that's bound up in consumer expectations, and those aren't independent of the law, you end up with rights accreting over time, right? And that's exactly what's happened in trademark law, and it's a vicious circle, and it's one that badly needs to be broken. Right, and I also agree that courts could develop doctrines that would break that cycle, and that they could be and probably should be norm shapers in this area. Right. So secondly, I agree with Stacy and Mark's implicit sort of normative assumption that there are a class of uses, or probably several classes of uses, that as a doctrinal matter are legitimate, and that as a normative matter ought to be legitimate. Right. And that the task then is really just figuring out tools to identify those uses and figuring out ways to keep them clear of trademark doctrine. Right, so Stacy talks about the Nike or Canon examples, right, and I agree those are good examples of places where you wouldn't want trademark law to get in the way of what would otherwise be effective forms of competition. Right, I'm not going to talk about the Red Sox because that's pathetic. So finally, I think I actually agree with Stacy and Mark, and then in this case sort of disagree with Graham and Mark Janus, that there is actually an implicit trademark use requirement in the Lanham Act. I think it comes from a different part of the statute than Mark and Stacy focus on. To me, it's really a function of the fact that in order to find someone liable, they have to be causing confusion, and they have to be causing confusion of a particular kind. So they have to be causing confusion about source, sponsorship, or affiliation. And you can't cause confusion about source, sponsorship, or affiliation unless you do something to indicate source, sponsorship, or affiliation. So to me, it's an implicit function of the fact that there's a requirement of a particular type of confusion in the statute. And that I actually think in some of these intermediary cases, we could get somewhere by just being more rigorous about focusing on the requirement that the defendant cause a particular kind of confusion rather than sort of confusion generally. So where we disagree is that I think that the trademark use that's implicit in the Lanham Act is a functional one. And what I mean by that is that what the requirement means is that the defendant has to use the plaintiff's mark or something similar to it in a particular kind of way, right? And that way that they have to use it is a way that does something, right? That it does something to indicate source. So the issue really isn't whether Google is using the Geico mark. I think indisputably it is. It's whether it's using the Geico mark in a way that does something, the way that conveys a certain message to consumers. And so that functional requirement means that as sort of a prerequisite for finding infringement in any case, what a court has to do as sort of a necessary step is determine what does this use by the defendant say to the consumers, because it needs to say something about source or sponsorship or affiliation in order to cause the right kind of confusion. Right? So the problem is that I don't see any tools by which you can make this determination in any kind of formal way. Right? So I think the only way to make the decision about whether a defendant has made a use that indicates source, sponsorship, or affiliation is to do it from the perspective of the consumers who are going to see it, and I don't see any tools that allow you to do that with any clarity ex ante. Right, so Stacy talks and Mark in their paper and today they talk a lot about uses that are clearly marketing one's own products on the one hand and uses that aren't on the other hand. And to me, I don't see a tool by which we can draw a clear line between those. So to me, to say when you want to know whether Google, for example, right, whether Google, when it uses the Geico mark, whether it's using it to brand its own services, there aren't any obvious tools for answering that question. There aren't any obvious things that we can fall back on except do consumers regard that as a source indicating use? And that's sort of the problem with the trademark use doctrine, is that even though it exists, it doesn't actually advance the ball very far because we're still ultimately falling back on a question about what consumers think, right? And once we do that, if we recognize it as a doctrine that forces us, I think like virtually all of trademark law does, to focus on consumer perceptions, we can't do that with a lot of clarity up front. We can't do it probably on a motion to dismiss, I would say, but more importantly, you can't do it as a potential defendant ex ante. Right? And I acknowledge that that's a problem, but it's I think a problem that's an inescapable one, at least the way trademark law is oriented at the moment. Right? So this isn't, I don't think, capable of being a tool like in copyright, like the DMCA safe harbors, because it doesn't define behavior in a way that people can predict knowably ex ante. So this is, I think, particularly true, and I can Stacy used some examples. A couple I use in my paper is that so you watch American Idol and you see the judges sitting there and they have large cups that say Coca-Cola on them, right? And as a matter of fact, that indicates something about sponsorship or affiliation of the show, right? So then, if we sort of have to ask, is that American Idol branding its own goods or services? I think the answer, as a matter of fact, is yes. Right? It is, in fact, they're branding it. They're creating an association, and Coke is paying them for that. Right? Or the example that I find sort of as far out to the boundaries as anything I've heard of is that 7-Eleven pays the Chicago White Sox to start each of their home nighttime games at 7:11 p.m. Right? Not a coincidence. So that, in fact, the time that the games start is an indication of sponsorship or affiliation. It, in fact, is a message of branding about the White Sox own products or services, right? And when we live in that world, I just don't see any way in which you can say that a particular use of someone else's mark is clearly one that doesn't indicate source or sponsorship or affiliation, right? It may be that we conclude ultimately that it doesn't, but it's not obvious to me what the rules would be to differentiate those two categories, right? And absent some kind of rules that make it knowable, it doesn't function as any kind of a threshold determination that a court can make. Right? It ultimately winds up being bound up in what they think about consumers. Right? So to me, what this really points up is that the real problem with modern trademark law is the sort of relationship between two factors. One is that it's all about consumer understanding. That's a problem in and of itself, but it's a particularly bad problem in trademark law because it's consumer understanding about something called source And the term source has gotten so broad as to encompass virtually anything, right? And that's the real problem, right? So the real problem is that when we talk about source, we're not just talking about the things that we sort of think of originally as source indicators. We're not just talking about using the swoosh on a pair of shoes. We're talking about relationships that go way beyond that and are much more tangential, and that when we recognize all of those in trademark law, as we do right now, as source relationships, that's the problem, right? The problem is that those are all treated the same under trademark law. Right? And so this is the place where I think that Stacy and I disagree probably the most, and that is that I actually put a lot of the blame for that at the foot of the search cost theory of trademark law, and that because that has increasingly been accepted, it's been too easy for courts to equate confusion with harm. Right? It's been too easy for them to see consumer confusion as the harm that they're trying to stop in and of itself. Right? Whereas that didn't used to be true. We used to think of harm as being something for which confusion was sort of a proxy or maybe a measure, that confusion is itself the problem because it interferes with search costs. And so that has, I think, allowed courts to be sloppy. It's made parties able to exercise or able to articulate claims in sort of confusion-based ways that sound at least facially plausible. Because you can sort of describe lots of things as creating some form of confusion. And so I think actually focusing on confusion itself as the problem is what has sort of led us into the situation we are. So the solutions then, to me, are to think much more carefully about what source ought to mean, right? And what kinds of relationships we care about recognizing. Right? And that even if consumers are confused about certain kinds of relationships, we just don't care. Right? We just don't care. So we might say, we could, and I think this is, I'm going to just speculate a little bit because I think this is an area where we all need to do more work, is defining the categories of behavior where we don't care. And so Stacy talks about some things that she identifies as these surgical instruments that insulate behavior, and I actually think those are great examples of how they don't work well in trademark law. And so, for example, descriptive fair use requires that the use be otherwise than as a mark. Right? That doesn't, to me, advance the ball at all, because if it's otherwise than as a mark, it's already not actionable. Right? So I think in that respect that it actually is a redundant exercise. And I think we could say the same thing about nominative fair use, comparative advertising. Both of those, at the end of the sort of test, are cabined by the phrase, as long as they don't cause confusion. Right? So all of these things are sort of attempts to identify behavior that's supposed to be okay, but only if they don't cause confusion, and so therefore they really don't add anything, right? Because if something doesn't cause confusion, we don't need a defense for it. Right? And so what we need are defenses or categories of behavior that are okay even if they cause confusion, or even if they cause certain kinds of confusion, and we need rules by which we can identify that behavior that are relatively clear, right? And so we need to categorize what kinds of source relationships that we care about. And so even if somebody could say, well, you know, people might be confused, right, about whether Coca-Cola sponsors that show because the cup is on the table, that we could say, and maybe this isn't the right category because maybe not everybody agrees, that, you know, we just don't care, right? That just doesn't bother us because for whatever reason, it's not a relationship that we think consumers need to know about or care to know about. But that until we can do that, until we can identify which kinds of relationships we're going to recognize within trademark law, we're never going to get out of this circle. We're never going to get out of this circle that we're going to have to keep recognizing whatever consumers sort of react to. Right? So I think one way to sort of say that simply is that we just simply don't have a rich enough account of the normative premises of modern trademark law to give us the categories that we would need in order to limit its growth. And so, you know, we did have those once upon a time. We're far removed from it. But we all need to think a lot more about how are we going to do that? How are we going to identify those behaviors? And I think normatively, right, the goal that Mark and Stacy have set out for themselves is the right one. The trademark use doctrine just isn't a tool that's capable of doing what they want it to do. It just can't carry the weight. So I will cede the balance of my time. So.
So, yeah, concern about clear lines. You know, this actually reminds me a bit of Mark J. and Graham's comment that sort of trademark use can serve as a wonder theory. That there is no silver bullet in the trademark use doctrine because it is inherently indeterminate in the same way that likelihood of confusion analysis is. You know, clear lines are difficult, right? Clear lines are difficult to find in any area of the law. But I'm not sure that persuades me that the pursuit should be abandoned. And I think that there are some cases in which a court can look at behavior and say, look, you know, this actually is a descriptive use of the mark. This is a descriptive term. It's being used not in a logo type way. It's being used in block print in the text of an ad. It doesn't look like a branding type usage to me. So even if consumers might be a little bit confused by that use, this is not a use of a mark as a mark. And I'm going to insulate this defendant from liability for this behavior because I think it serves important competition-related goals. And I think the courts are capable of doing that same kind of thing in these intermediary cases in ways that, again, don't let intermediaries off the hook necessarily, but that make clear that they are not themselves branding their own products under the mark if they are simply using the mark as an indexing tool to call attention to competitors. I know I only have 3 minutes and I've used 3.5 of them. So my final point is that on this sort of mucky lines point, Mark didn't get to this point, but I'm not sure that his normative suggestions are any less mucky than ours. And I think this is the problem with, and I think this is true with the critique of trademark use generally. We're not saying it'll solve everything. We're saying it'll hopefully promote some important normative goals, policy-oriented goals of trademark law to recognize this kind of safe harbor in some cases. We're not saying it's perfect, and I think the critics don't really have very satisfying alternatives to replace it with. And we can have a conversation about some of the alternatives that Mark has proposed. One of his suggestions is that we turn to sort of diversion, confusion that might actually divert consumers from the trademark holder's product to some other product. I'm not sure that gets you very far, and it itself could. It does turn on consumer expectations, and expectations about endorsement actually can have ultimate effects on the sale of products and services, or on diversion of product sales. Anyway, I've taken up too much time, so let's turn to questions.
I'm just wondering what you guys think of the KP Permanent case in the Supreme Court, which, because I always, when I taught trademark law, always had the same thought that Mark expressed, which is that descriptive fair use and nominative use, if you read the case law when I started teaching, pretty much just reverted back to the consumer confusion case and weren't particularly effective carve-outs for particular kinds of favored behavior. And then I took some heart when the Supreme Court actually intimated that sometimes it's okay for consumers to be confused and we shouldn't, automatically side for the plaintiff. So do you think that changes the landscape at all, whether that's any hope, or is that just as hopelessly indeterminate in the end as the previous case law?
Well, yeah, it certainly it gives me heart, and I think it actually illustrates the point that judges are capable in these, in some of these cases at least, of characterizing the defendant's behavior without resort to consumer expectations, of saying, look, I can look at the nature of what the defendant is doing here, the context in which the mark appears, and make a judicial determination that says this is not a trademark use without having to rely on the circularity of consumer expectations. And I think courts are capable of doing it. I think I just have a lot more faith in courts to draw lines than Mark does. I acknowledge it's messy sometimes, but courts do that all the time.
So I acknowledge she has more faith in judges than I do. So I actually think that what's played out after KP Permanent is actually great evidence that the KP Permanent decision is not going to be that important. So the decision, I think, symbolically, right, seems to suggest even if there's confusion, uses can be fair, and that maybe that's a legitimate way. But what it left open was the question of how do you know whether it's in good faith and otherwise than as a mark. And as what we've seen in the litigation when it went back down to the Ninth Circuit is that courts can't get away from using the question of whether it causes confusion as a measure of whether it's really in good faith and otherwise than as a mark. And so I think it just pushes the question of whether something is used as an indication or that it's causing confusion to a different part of the analysis. But ultimately, and I think this is what's played out in all the cases after KP Permanent, it doesn't actually change the fact that at the end of the day what the court is evaluating is whether they think it's likely to cause confusion. Right now, I think Stacy has intuitions about cases where that will be true, where something isn't going to cause confusion, so that she thinks it's clear that if something is just in the text that won't cause confusion. And I think that maybe those intuitions are in many cases right, but it's not obvious to me that it will always be right. And that's why courts have left open that possibility at the end that as long as it doesn't cause confusion, because even in the text, they could imagine cases where it would in fact cause confusion.
Thank you both for a great presentation and an enjoyable afternoon. I'm struck by the fact that we are going quickly to Google and quickly to the problem of indirect liability and perhaps missing the interesting problem. I need to find a direct infringer before I can worry about indirect liability, let's imagine. And you've given some of the easier cases so that I've got the Boston Unfortunate Team or whatever they are. And I've got the Nikon and Canon. Let's turn into a hypothetical. Let's say the Sixth Circuit case of Holiday Inns versus 800 Reservation. Because that might be the category where someone might say there is a likelihood of confusion, but we just don't care because it's not a use. To make it analogous, let's imagine the defendant might be the telephone company or whoever it is that sells 1-800 numbers and who happen to sell the tracking number 1-800-H0-LIDAY to somebody that we know is intentionally actually causing predatory diversion, is intentionally actually deliberately causing actual confusion, and is actually taking the customers from Holiday Inns and reselling them back to Holiday Inns. I'm curious to ask the question, that's a long threshold, I guess, but the question is, would you, either one of you, comment on, is that an infringing use because it causes a likelihood of confusion, or is that either not an infringing use or we just don't care? Is that the category we're looking for, a don't care case where there was clearly likelihood of confusion?
So I'm always a little wary of that case being used in this context because I'm not really sure that case can be extended really anywhere beyond its facts. I mean, I think I think if there was a principle there, the principle would be something like if you don't actually present the mark to the consumers in some way, right, which arguably they didn't there, they just presented the number, right? If you don't actually present the mark, then you're not doing anything. But I actually think that principle doesn't stand up because we can actually, I think of lots of circumstances where somebody wouldn't present the mark but might respond to it in some way. If you go to a restaurant, you ask for Coca-Cola, they bring you a brown liquid. They haven't done anything to present the mark to you, but I think we would all assume that if that wasn't actually Coke, they're doing something that would at least count as unfair competition. So I don't really think the principle even gets you beyond the case. So what about that case? I always have a hard time when I'm teaching it, trying to figure out exactly what to say about it, except that if you're a defendant and you use a phone number that corresponds to a mark, but you don't actually ever present the mark, then that's okay. And I don't really know what else to make out of the case beyond.
So we could just say the case is wrong, but because
I have a hard time getting to saying it's wrong.
Well, you have to assume that the consumer thinks that they're trying to dial 405 instead of 465, and that's an apples to oranges. The apples to apple is they're trying to dial Holiday, and we're asking whether Holiday has looked, whether it has sight, sound, or meaning, whether Holiday looks like Holiday. whether the O looks like a 0. And it would seem like to accept that case, we have to give up on a whole lot of sight, sound, and meaning cases, because they'd all be wrong, I guess, because I'm not presenting the mark. I'm presenting something else.
Well, I think the other thing that is raised by that case and also by a number of internet-related cases is this question of initial interest confusion, right? So if there is confusion among consumers, as soon as they get to the operator on the other line, they know who they're reaching, right? So you have to go through two hoops to find actionable confusion here. You have to, number one, find that the party is engaged in trademark use, and number two, accept the doctrine of initial interest confusion as a basis for finding of infringement. Now, I think the interesting parallel in the online context, and one that Mark and I deal with a little bit, is what about the parties that purchase these keywords, right? They are selling their own goods and services. They are using the marks as a device to call attention to their goods and services. And we're not willing to dismiss the possibility that in some circumstances there could be a Coke-Pepsi thing going on here, right? That the text of an ad could actually deceive consumers into actually thinking that that ad is responsive to their search when it is in fact not. So there may be some circumstances in which the advertiser itself is using the mark in a deceptive way in connection with its goods and services. But a ruling that would put the intermediary on the hook as a direct infringer would effectively impose strict liability on it for those circumstances, and I'm troubled by that.
I think I agree with most of what Stacey said, but I would just say I think the context that she's contemplating is not liability for use of the keyword. It's the use in the context of the ad, right? So which may have some relationship to the fact that it's generated in response to the keyword, but what she's talking about is triggering the liability has to do with the context of the ad itself that's presented on the page. That really sort of moves the liability ball down the chain.
No, I actually, Mark and I have had a lot of conversations about this. I actually think that there are situations in which someone could place a deceptive ad that does not actually include the trademark, but that suggests that the trademark holder somehow stands behind the product given the context of the ad in response to a trademark-based search.
Okay.
Yeah, but yes, the text of the ad is critical.
Right, but the act of buying the keyword itself is not enough, right?
That's right. That's right.
So
that's right.
Which
not
I think rejects
well.
the initial interest confusion in its broadest sense.
Yes, absolutely.
Stacey, this is to you. One of the things I kind of got this flavor when I now teach the use cases because Mark has plugged them into his IP survey book as his first thing. You do kind of almost leave yourself wanting to say, kind of, and this buys a little bit toward Mark's argument. Isn't this just a case where it was just summary judgment of no likelihood of confusion? And I guess I'm trying to tease out where are those cases? Are there these cases where if I went through the factors, I at least would say there's a possibility, so I've got to try this case, and so I need this use kind of gatekeeper to throw these out early, kind of an efficiency also to make sure judges don't make mistakes. And what's the differential between, like we have in AMF versus Sleekcraft, there's a short likelihood of confusion analysis, right? Whether this kind of, are they the same products, or are they comparable products? And if they aren't the same products or comparable, we just throw it out and say it's no confusion, and that's it. I'm just wondering, what are those unique cases where use is important, where I can't use a summary judgment of no likelihood of confusion?
Yeah. So I think as the post-KP permanent case law develops, because I'm gullible and have faith in the courts,
which is
I actually
her Red Sox fandom.
I actually feel some hope at least that that's an example, right, where courts may be able to grant summary judgment on the fair use issue, even with some background conceivable possibility of some low-level confusion, right? But the other area and the critical area that we're focused on here, in which I think this can serve a useful function, is in these cases involving intermediaries, involving what we view as third parties who are, at best, facilitating someone else's infringement. And I think the Ninth Circuit opinion in the Playboy Netscape case is a perfect example of this, right? Netscape is automatically strictly liable for any plausible confusion that might occur because of advertisements placed in response to searches for Playboy. A much more contextual approach would look at Netscape's role in facilitating these advertisements, what it knew about what its advertisers were doing. But by saying that Netscape is actually a direct infringer based on confusion that might occur as a result of its advertisers' placement of these ads, I think the court automatically gets you into this whole analysis of likelihood of confusion and prevents the case from being cut off at an earlier stage. Now, the case actually might end up being litigated, going to trial, but it would be on a more specific question of contributory liability, which I think is a much more cleanly defined. I wouldn't say cleanly defined doctrine, but a much more limited doctrine, certainly.
Having just taught that last week, I object to the cleanly defined.
I retracted it.
So I guess what I would say about it is that I think that at a level of generality, we hear people talking about sort of these possible classes of cases that trademark use deals with, but when we start talking about specific examples, they almost always devolve into questions about search engines and search engine liability and these intermediaries. And what I would much prefer to see would be something like the DMCA safe harbors. I would much prefer to say people who are these kind of actors are just exempt from liability if we really think that that's sort of they're doing virtue, rather than try to develop a doctrine which, I think trademark history teaches us will not be cabined to those kinds of circumstances, and that I don't know how it will work and other things. So I'd much prefer to say, if we think intermediaries, and particularly online intermediaries, are doing a valuable service by selling these keywords, then we ought to just create a safe harbor for them like we did in the DMCA.
And I'll just add that the DMCA was a codification of common law principles.
Contested common law principles.
Just because I had to get the last word.
Okay, before I get caught in the middle, thank you both very much. And thank you all for being here, and we'll have a light lunch in the